Well, good morning again to all of you. As with all conferences I've been in all my life, we are already having a timing problem. One is always too ambitious, trying to bring in too many issues, too many speakers, and that's where we are. As I spoke already this morning, which was not really planned, I will not speak now as it was planned by introducing the topic, because we have much more qualified speaker this morning to raise issues on this specific topic. We have afterwards, as you know, the book launch. I saw that some of you were already very smart in getting their advanced copy of the book, but we will distribute them for all of those who are interested after the launch within an hour or two. We have 4 distinguished speakers this morning. They will make short introductions to try to have a little bit more time for discussion afterwards. I know it will be quite difficult, so we will have Claudia Höfner starting, senior legal advisor to our judges, 15 years of experience. I'm not going into the CVs are in your documents. She will more speak about the role of women more from an institutional perspective as focal point for women. But Michelle Jarvis, many of you know her, my deputy in The Hague, instrumental in putting the agenda of gender justice forward, initiator and chairperson of the working group we had to move the book project forward. So she will speak more about our lessons learned and very much about what next. Because what we have done in the past you can read in the book, but for the future this will be the next publication, and Michelle, we will be working on. Kirsten will more look at it from an academic perspective. She has worked on a number of projects, taking a little bit more, not helicopter view, but a little bit more distance towards the problem, the jurisprudence, the work we have done. And then finally, I would say, almost most importantly, if I may say, the other will forgive, Adriana, she will speak about the activities at trial, which is one of the few organizations which are really taking very, very seriously in this country the rights of victims by helping them, representing them, supporting them before justice, still fighting for compensation, reparation. We all know that this is an issue which has been discussed many, many times in the past, where there is still no satisfactory solution. So very pleased that you are with us, Adriana, to speak about your part of the work. With this short introduction, Claudia, it's your turn.
So does it? Yes, it works. Ladies and gentlemen, when you hear gender justice legacy of the ICTY, you first think, of course, about the prosecution of gender-related crimes. But there's also another gender-related legacy of the ICTY, and that is its legacy concerning institutional gender strategies to promote gender equality and a gender-sensitive working environment. Sorry. Okay. Thank you. Why do we also address institutional gender aspects in today's panel? Because their relevance for the good functioning of a war crimes court, as well as for the effective prosecution of sexual violence crimes, cannot be underestimated. Before I speak about some of the ICTY's institutional gender strategies, I would just like to say a few words about myself and then the role of the focal point for women. As Serge already said, my name is Claudia Höfer, and I have been working as legal officer in chambers of the ICTY for the past 16 years. Besides being a team leader and senior legal advisor to the judges, I'm since 2014 the ICTY focal point for women. Okay. Before I took that position, Michelle Jarvis had been the focal point for women for 4 years. The mandate and role of the focal point for women derives from policies to achieve gender equality in the UN, and is defined in a Secretary General's bulletin, according to which focal points for women shall support the head of department in achieving gender equality. The tasks of the focal point include advice to women staff in cases of discrimination, harassment, and abuse of authority, counseling on career advancement, as well as monitoring the staff recruitment and selection process in order to ensure that all eligible women candidates are given due consideration. I will now present 3 areas where, in my view, the ICTY did have an impact on the achievement of gender equality and a more gender-sensitive working environment. I will then touch upon the gap in women's representation at senior management positions and possible means to address it. Recognizing the importance of a healthy working environment where staff is treated with respect and dignity, the ICTY organized in-house training for all staff regarding the prohibition of discrimination, harassment, including sexual harassment, and abuse of authority. This training was provided collaboratively by the Chief of Human Resources, the Focal Point for Women, and the Staff Welfare Officer, and also included specific training for staff in management positions. It provided a forum to discuss sensitive issues and also showed staff that the principals and senior management of the ICTY took cases of discrimination and harassment seriously. It has definitely raised the awareness on what amounts to discrimination and harassment and empowered staff to take action against it. In this context, it is also noteworthy that the judges agreed last year on a code of professional conduct for the judges of the tribunal, which also provides that judges shall not engage in any form of discrimination, harassment, including sexual harassment and abuse of authority. This express commitment is important, as the Secretary General's bulletin on the prohibition of discrimination and harassment is only applicable to UN staff and not to the judges. The UN recognizes also flexible working arrangements as an important means to ensure a healthy work and life balance. It was also based on the Focal Point for Women's initiative that the ICTY in 2013 hired a specialized consultant to advise on flexible working arrangements, specifically tailored to the ICTY's unique circumstances as a court, UN institution, and downsizing entity. While the ICTY had already some flexible arrangements in place, it wanted to improve productivity and morale by allowing for a better balance between the professional and personal lives of staff. After holding meetings with representatives of the different organs of the ICTY and discussing their needs, the consultant provided a number of recommendations, which resulted in newly approved arrangements, including relief time and remote work, and amendments to the existing flexible working arrangements. These arrangements were first offered to staff as part of a 6-month pilot project, which review mechanisms in place and are since then available to staff, provided the supervisor agrees to it. While supervisors and department heads were encouraged to support this program whenever possible, some reservations have remained, in particular when it comes to productivity and quality of outputs. There are also staff members who are still reluctant to request flexible working arrangements, fearing a negative reaction from their supervisor. However, speaking at least for ICTY chambers, flexible working arrangements have become practice now and are used to the satisfaction of both staff requesting them without fear for repercussions and their supervisors who even notice an increase in productivity. When the closure of the tribunal became imminent, the Office of the Focal Point for Women organized a mentoring program for ICTY and ICTR women staff to support them in navigating their career. This Empowerment in Leadership initiative was launched in September 2013 and aimed to leverage the leadership potential of women staff by training, coaching, and encouraging them in their journey towards leadership positions. It was not only praised by participants in the program and the ICTY management as effective in achieving a real change for women, but also referenced as a positive example by the Secretary General on the improvement of the status of women in the UN system. Following the positive feedback from the participants, a second round of the program was launched in 2015. Again, participants received training on how to use mentoring and networking as an effective tool, as well as help with identifying and approaching mentors who can provide career transition support. These three actions to foster a gender-sensitive working environment and to provide career support to women have become known in other UN institutions and criminal courts in The Hague, who have been reaching out to us for assistance and to learn more about it. When it comes now to gender parity at all levels, it is very concerning that until today, irrespective of all policies, special measures and action plans of the UN, it is still far away from reaching this goal. As stated in a briefing note from the meeting of the Staff and Management Committee in April this year, the senior leadership level across the whole UN comprises of 29% women and 71% men. It should be noted, however, that the ICTY has been a positive example in approaching gender parity in senior management positions over the last years. Coming back to the UN-wide gender gap, I would like to outline two measures which could help to overcome it, in my view. The first one is the involvement of the Focal Point for Women in the recruitment process from the very beginning. Currently, I'm reviewing the recruitment process only after the interviews of the candidates have taken place and a list of suitable candidates has been already produced. This is, in my view, too late in order to have a real impact. It would be important that already at the pre-selection stage, the Focal Point for Women could ensure that at least 50% of the pre-selected candidates are women, or otherwise advise to re-advertise the position. Moreover, the Focal Point's monitoring ends with the review of the list of suitable candidates, which means that even if women candidates have found to be suitable for a certain position, this doesn't guarantee that they will also be selected for it. And when it comes to promotions, the Focal Point for Women is not at all involved. Thus, the mentoring by the Focal Point for Women could be made more effective in order to ensure the selection of women. The second measure would be to require the mandatory recommendation and selection of female candidates until gender parity is met at all levels, and to require the hiring managers to provide written reasons if no women were hired or promoted to senior level positions at the end of the year. The Secretary General has made a commitment to reach parity at the senior leadership level by 2021, and parity across the UN well before 2030. There is some hope that the newly created Gender Parity Task Force will develop clear criteria on how to implement the staffing targets and monitor their implementation. And I hope that the gender gap will also be closed at the level of the judges, and that future international courts will consist of an equal number of female and male judges. Thank you very much for your attention.
Claudia, thank you also for those recommendations and personal opinion. I think it's it's important. And I'm also pleased to hear that at ICTY we are doing relatively well. In the OTP, I think, as well, and in this panel, we are having an excellent gender balance. So, Michelle?
Thank you, Serge, and good morning, ladies and gentlemen. Back in 1993, when the Security Council took its then unprecedented decision to create the ICTY, strong statements were made that justice for women would be part of justice at the ICTY. The international community's understanding, though, of justice for women was heavily bound up in the concept of conflict-related sexual violence. Dominating the discussion were, of course, reports of rape camps, deliberate impregnation of women and girls, rape pursuant to military orders, and of course the sheer volume of suspected crimes, some reporting up to 70,000 victims affected. So it was clear from the beginning that the ICTY would be expected to address sexual violence crimes, and this informed the drafting of the statute and the rules of procedure and evidence. So we saw, of course, rape expressly mentioned as a crime against humanity, despite the fact that at that time there were very few historical precedents for this. And we also saw rules adopted to ensure quite progressive approaches to evidentiary matters and witness protection matters in sexual violence cases in particular. But as we found in the OTP, operationalising this accountability objective proved to be one of our most significant tests in the implementation of our mandate. How could the OTP reach out to victims traumatised and scattered all across the globe? How could we surface the reality that sexual violence affects males and females? How could we convince the survivors to speak out, despite stigma and other barriers to doing so? And how could we move beyond the physical perpetrators of these crimes to hold accountable the political and military leaders who tolerated or condoned or even encouraged pervasive patterns of sexual violence? Over the years, of course, the OTP came up with many, many strategies to address these challenges and also others. Of the 161 persons indicted, 93 faced charges involving sexual violence. We have convictions for rape as a crime against humanity, but we also have convictions for sexual violence as torture, as persecution, and as enslavement. We have convicted direct physical perpetrators of rape, but we've also held senior military and political figures responsible for their role in sexual violence crimes, using theories like joint criminal enterprise, command responsibility, and aiding and abetting liability. These have been hard-fought successes, and it's right that today, at this conference, we should acknowledge them. The work of the ICTY, together with the courts and tribunals that followed, especially the Rwanda Tribunal and the Special Court for Sierra Leone, have helped reverse the historical indifference to this category of crimes. But among the successes, we know that there were missteps and missed opportunities along the way as well. So in the Office of the Prosecutor, we've carried out a comprehensive review of our experience, and we've aimed for a very honest reflection. We didn't want this to be a sanitised account of the achievements. We wanted to really dig into the operational insights, to look at what things worked, what things we would have done differently with the benefit of the hindsight that we now have. And so last year we published the results of this study in a book called Prosecuting Conflict-Related Sexual Violence at the ICTY, which is co-edited by our moderator today, Serge Brametz, and myself. And I do have to acknowledge the tremendous support that OTP management at the most senior levels gave for this project, and we could not have done it without that support coming from the top. And following our discussion this morning, we will, of course, at a side event, launch the Bosnian, Serbian, Croatian translation of this book, which we are particularly pleased to make available because we know that this allows us to engage with our peers here in the region at a much more concrete level. We've also set up a new network on prosecuting conflict-related sexual violence crimes through the International Association of Prosecutors. And the idea here is to really channel all of these developing insights globally so that as practitioners we can continue to do better and better with our work on these crimes. Our recommendations for the future are very many, but in the time I have left I just want to focus on 3 key points. So first of all is the ongoing challenge of creating the right conditions to bring evidence of sexual violence forward in criminal proceedings. Despite the progress over the last 2 decades, there has also been an entrenched pattern across many jurisdictions of sexual violence evidence being missed in investigations or surfacing only when it's too late to include them in prosecutions. And the most recent example of this, of course, is the Hissène Habré case prosecuted in Senegal. In a very familiar pattern, new evidence of sexual violence, including rapes by Habré himself, surfaced only in witness testimony when the case was already underway. And although efforts were made to belatedly amend the indictment to reflect this new evidence, the direct physical perpetration of sexual violence convictions were overturned on appeal because of late notice issues. The reasons for the failure to uncover evidence of sexual violence in a timely manner are, of course, very many and very complex. But our experience at the ICTY definitely confirms the importance of now taking stock of what we know and committing to reinforced efforts to overcoming this through creative strategies. Delay in victims speaking out about sexual violence crimes is absolutely a reality. We need to acknowledge this, but at the same time, we have to adopt creative strategies to counter it. Here in Bosnia, we know we see cases where women are speaking out for the first time 20 years after the crimes have happened. So how can criminal justice actors work together with community leaders, with religious leaders, educators and the media to address the problem? For example, the UN Commission of Inquiry on Syria has an interesting finding in relation to crimes committed against Yazidi women and girls. They've noted that religious leaders among the Yazidi community have spoken out in strong support of sexual violence survivors and urged compassion. And they've noted the impact, the positive impact that's had on the willingness of the survivors to speak out. And indeed, we saw at least one similar example in our own work at the ICTY, where religious leaders really played a very positive role in creating space for victims to speak out. Another fact that we know negatively affects our evidence collection in sexual violence cases is the way that criminal justice actors think about sexual violence. We confronted misconceptions that led us to mischaracterise sexual violence and to discount its seriousness compared to all of the other atrocities being committed. And we also confronted the pervasive discomfort that we still feel in asking questions about matters perceived to have a sexual component. It's obvious that training is crucial in overcoming these negative stereotypes and misconceptions. But is it happening on a systematic and mandatory basis in the prosecution offices globally now dealing with these crimes? I really have grave doubts that it is, but I really hope someone can prove me wrong sometime soon. And if part of the problem is hidden bias, this idea of misconceptions that we may not even be aware of ourselves, would it be useful to now bring in some insights from the behavioural theory world, for example? One of the projects that we're exploring within the PSV network currently is whether we could use a concept called inclusion nudges to redesign prosecution strategies and policies to be more inclusive of sexual violence crimes and to help us characterise them more accurately. The second area to focus on for the future is to extend the honest reflection on what we know beyond the prosecution. So over the past year since our book was published, we've spoken to many, many different audiences about our findings. And one question that comes up repeatedly among these audiences is, it's great that the OTP has done this, and it's great that similar processes are being done by prosecution officers at the Rwanda Tribunal and the Special Court for Sierra Leone. But what about the judges? And for that matter, what about other actors in the criminal justice process? Has there been a similar process of reflection and review, drawing on the experience of the past 2 decades? As far as we know, there hasn't been, but we absolutely agree that it would be such a positive step and valuable contribution to the dialogue to add in these varied perspectives. And it would, for example, be great to see a body like the International Association of Women Judges spearheading some kind of review like this. And my third point is the need to expand our understanding of gender beyond the issue of sexual violence. And so I loop back really to where I began in my remarks. The focus on gender at ICTY has largely been limited to sexual violence cases. And although we've seen in our experience the importance of recognising that sexual violence affects males and females, we also have to understand that that doesn't make it a gender-neutral issue. Gender, the socially constructed roles of males and females, influences everything from the form that the sexual violence takes, to the purposes underpinning it, to the harm experienced by the victims, and especially the social harm experienced as a result, and certainly it affects the reaction of criminal justice actors to it. As practitioners, we learned this crucial lesson of viewing sexual violence in a broader gender framework. So our challenge now is to take this growing understanding of gender into other parts of international criminal law. And we've seen some glimpses, at least, of what this might look like at ICTY. So, for example, we've seen gendered patterns of crimes, such as in Srebrenica, where men were overwhelmingly targeted with killing, and women and girls were overwhelmingly targeted with expulsion crimes. And we've seen the importance of adequately addressing all categories of crimes. We've seen difficulties that we faced in bringing forward women as witnesses in criminal proceedings to testify. At the ICTY, the statistic is just 13% of our witnesses have been women. And so, invariably, we have an understanding of the conflict primarily based on the experiences of men. We've learned many lessons about prosecuting crimes like unlawful attacks against the civilian population, another category of crimes that may have a disproportionate impact on females because they tend to make up the majority of the civilian population. In other jurisdictions, we've seen issues arise like crimes committed by victims, against victims by their own side to the conflict. Again, an issue often having a particular significance for females who are prone to rights violations by so-called friendly forces. To really expand gender perspectives in international criminal law from here, we need to improve our understanding of the distinctive impact of conflict on males and females and then map that against the concepts that we regularly use to construct our cases. It seems obvious that gender must influence our understanding of concepts like what is an armed conflict, the principle of proportionality, the principle of military necessity, what is humane treatment, what is an attack, what is a fundamental rights violation, what is discriminatory intent, and what does it mean to destroy a group. So plenty of challenges ahead, but I think we can take courage from the indisputable progress of the last 2 decades. I think what we can say at this point is that we have a much clearer idea about the questions to ask, and so the challenge now is to move ahead with finding some new answers. Thank you.
Thank you very much, Michelle, for part 1 of your presentation. If you want to hear more, you have to come in 1 hour to the book launch, where Michelle will say a little bit more about this issue. We have, of course, been very fortunate at the Office of the Prosecutor, not only because we had a fantastic team helping us putting this book together and putting those lessons learned together, but also because we have many external partners who are helping us, which has as a result that we have organized training on those issues in East Africa, in Latin America, and we have many other requests to do so. And I really want very briefly to thank the president of the International Association of Prosecutors, Mr. Jarosz, who is with us and who will speak later on. It's of course very much thanks to our International Association of Prosecutors with 250,000 members that we can spread the good message to our colleagues around the world. And I'm sure that the colleague Gerhard will say a few words about it later on, but we are also very pleased to have other organizations who are believing in what we are doing, like the Nuremberg Academy. We have the acting director, Christian Much, with us, so also thanks very much to the Nuremberg Academy to make on a regular basis funds available to allow us to organize those capacity building projects, which is really, really great, a great support. Well, we are moving to Kirsten. A little bit more academic perspective, even if you are doing a field study which brings the two areas together. You are working on a gender justice framework, which sounds great. What is it in practice?
Okay, so I would first like to thank the organisers of this panel for opening this space for this panel. Thank you, I thought it was on. So, I'd also like to note that this is a presentation that is co-authored with Gorana Milanovic. So, taking up Michelle's question, what are the legacies of the ICTY for gender justice? In this short presentation, we argue that a key gender justice legacy of the ICTY is in fact an important challenge. Namely, how do we build a so-called gender justice framework that can provide greater accountability for gender-based crimes? And I should note here that our contribution intends to open dialogue rather than to provide a final answer to these complex but important questions. So I'd like to begin with a very quick engagement with this question of the legacies and lessons of conflict-related sexual violence prosecutions before the tribunal. To take up Michelle's points, one key positive legacy, of course, is the tribunal demonstrated that it was possible and necessary to undertake the prosecution of sexual violence as an international crime. This is clearly now an established part of the tribunal's legacy. Equally importantly, as we've also touched on, was the establishment of international norms and procedures at national levels, most notably, of course, at the BIH State Court. Now, with these positive legacies also came some rather more negative legacies. And as Michelle has mentioned, one of those was the focus on sexual violence. The struggle to establish sexual violence as an international crime focused time and resources on sexual violence, to the neglect, one could argue, of what we might call now gender-based crimes. As a result, sexual violence came to be seen as the focus of what we now call gender justice, rather than gender-based crimes more generally. Another more negative legacy is what we would describe as an underdeveloped legal and institutional framework. We have to recognise the challenges of undertaking the prosecutions of these offences within the significant limitations of existing legal and institutional frameworks, as have already been mentioned. This includes, of course, an underdeveloped legal concept of conflict-related sexual violence as a gender-based crime. And so, for example, here, we might want to talk about the challenges of a gender-neutral model that can obscure, in fact, different patterns and consequences of these offences for men and for women. So with these positive and negative legacies, there are also two further what we can call mixed legacies. On the one hand, and this is the importance of the OTP book, we see that we can now see the importance of a gender perspective for effective prosecutions of sexual violence. This book shows the absolute crucial importance of having what we could call a gender perspective or a gender analysis for effective prosecutions. However, at the same time, we also see that there is no wider framework for gender-based crimes. And moreover, we see that there is no wider framework, as has been mentioned, for all sections of judicial institutions. Here we should note that national jurisdictions in the former Yugoslavia have not yet developed such gender policies. And here we could also note that this is an important opportunity to build on the important legacies of the work of the prosecutions in this regard. We should also turn our minds to, and here I'm extremely mindful of our discussion this morning, the absolutely important synergies between international and national prosecutions of sexual violence, because all these legacies have important implications for national prosecutions, both given the synergies between international and national prosecutions of sexual violence, and that national courts remain the principal venue for such prosecutions. We need to recognise that these synergies go beyond the presentation of the prosecutions themselves, but they in fact also have profound implications for how the gendered nature of conflict is presented, how it is understood in public narratives of the war, and how it impacts on post-war narratives of gender relations in society. So what we see then is that we now have a gender perspective, and we also see this in courts such as the ICC. However, this focuses on prosecutorial strategies, analysis of bias in legal institutions, and addressing gender representation. We would like to suggest that it is now time to move from a gender perspective and to develop a gender justice framework. This involves 4 key shifts. The first shift is from a specific, limited understanding of criminal accountability to ideas of gender justice. The idea of gender justice is relatively new, and we can define it in its most basic elements as this idea. How do prosecutions contribute to changing social inequalities, and in particular gendered inequalities in a society? How do they intervene or not intervene? How do they change or indeed not change the gender dynamics of societies after conflict? That's the first shift. It's a broader framing for how we think about the contribution of prosecutions. The second shift is to shift from OTP policy to criminal justice systems as such. The work of the OTP has been crucial, but clearly successful prosecutions of gender-based crimes require all segments of the criminal justice system to be involved. The third shift is to shift from the focus on sexual violence to gender-based crimes, and is here where we see the most significant development required. Finally, the fourth shift is that we need to build so-called gender justice in its specific conflict contexts. We need to have policies and frameworks that address those inevitable synergies between international and national prosecutions, and we need to acknowledge the links between prosecutions and affected societies. So what we would like to present then is an exploration of guiding principles, because we can't offer specific details. They will be specific to that conflict, to the needs of that society, and to the specific needs of that institution. So let us begin by setting out these principles. I decided not to torture you with PowerPoint. Okay, the first principle. We would argue that a crucial step here is the development of appropriate models of the concepts of gender, as Michelle has mentioned, and also gender-based crimes for international criminal law. It is clear that when we talk about gender-based crimes, or indeed sexual violence as a gender-based crime, that we somehow assume that gender is a thing that is out there. But of course it requires analysis, investigation, and understanding in the specific context of that society and that conflict. So, on the one hand, we would argue that we need better models of gender and gender-based crimes at the level of ICL in our legal regime, but we would also argue that appropriate models of what gender and gender-based crimes are need to be developed for each specific context in which those crimes are prosecuted. The ICC OTP policy goes some way to suggesting this when it talks about gender analysis. However, that gender analysis is obviously a highly complex issue. It requires expertise of all kinds. And so it is inevitably necessary to really unpack what we mean by gender and gender-based crimes. One suggestion, for example, we had is that we could consider what the CEDAW shadow reports tell us about specific conflicts. The second principle is that we need to undertake doctrinal development of legal norms in this area, as Michelle has mentioned, particularly in relation to substantive elements and modes of liability. The recent decision in ICC of Nataganda is an example of this. Third principle, we need to identify and address gender norms, power and power biases in the values, design, culture and established practices of legal institutions. It's clear that all institutions carry certain ideas of values, not just about senior management, but also about what we value in our practices. These need to be considered. Principle 4. We need to integrate gender analysis of the conflict into criminal and civil justice processes. The aim here is to ask, how do we capture different gendered patterns of harm and conflict, and how do we ensure there are appropriate legal responses to them? Principle 5. We must provide significant and active and meaningful victim participation and protection in the criminal process. We have many suggestions for how this might be done. Finally, Principle 6. It is necessary, vital, to undertake active engagement with the affected society to incorporate prosecutions into post-conflict social transformation. Prosecutions are inevitably part of our post-conflict society. So the question is, what part are they? And with this in mind, that's our greatest challenge for any gender justice framework.
Thank you very much, Kirsten. When will we get the results of your study? Well, when will it come out? Any date already?
2017. Yes.
A year from now? Good. End of this year. Yeah. Anyway, so fingers crossed. It is very interesting, a very complex exercise. So we are really looking forward to see the entire work you have done in this regard. Last but not least, Adriana, Senior Legal Advisor at Trial, coming really very much down to earth to the day-to-day problems you are experiencing by supporting victims. So we are very much looking forward to hear what you have to tell.
Thank you very much. Ja sam odlučila pričam danas na našem jeziku iz poštovanja.
Thank you. I will speak Bosnian as a mark of respect for the representatives of the victims present here today. First of all, I would like to welcome you here. And I would like to mention one more thing. I have already been introduced as a person who is going to talk about reparations, and I want to say that I'm going to speak about reparations through criminal proceedings, because this conference is dedicated to criminal prosecutions before ICTY and national jurisdiction. I believe that the representatives of other organizations here are also going to take part in the subsequent discussion. First, a preliminary question addressed to the audience. Do you believe that victims are entitled to reparations? I believe that everybody here believes that that is correct. Anybody with the minimum amount of empathy should agree. And yet, although everybody here in Bosnia-Herzegovina agrees about the answer to this question, when we go into the field, when we discuss it in practice and especially in the practice of judicial institutions, things get much more complicated. We have behind us 3 failed attempts of various associations, 3 failed attempts before the parliamentary committee of the Bosnian parliament to adopt the law on torture, so that this law would also enshrine the right to reparations. Now we are before our 4th attempt. Last year, the Constitutional Court decided that the claims for compensations are already beyond statutory limitation. So it means that, for example, a victim of rape in the war should have returned in the entity from where she was expelled, and by 1999 she should start a civil suit in order to get some compensation. I think this is completely unrealistic. Our system of social protection is very patchy. We have a certain degree of care for the victims of war crimes, but this care prevents many of the victims across Bosnia and Herzegovina to achieve justice, because when we speak about particular conditions, they are very, very restrictive. As for the criminal prosecution, I have to say that up to 2015, all claims for reparations were completely ignored, especially when we talk about victims who were protected during the criminal proceedings, because if they have to achieve their reparation in a private lawsuit, then they have to lose all the protection, which means that they're unable to get any compensation or reparation. Since 2015, we have seen various efforts of various stakeholders, judges, prosecutors, civil society organizations from Bosnia and Herzegovina and other neighboring countries, and we have managed to have 1 victim who was awarded reparations, 1 victim of sexual violence. So 1 up 2015 and 8 since 2015. They involve 10 victims from all 3 constituent peoples. What can we do next? Is this an ideal model for reparations? Is this the only model that should exist? Most definitely not. It's only one of the possible ways of reparations. However, it is rather limited. It is limited by its own nature, because it means that only the victim who was so lucky that her case was prosecuted in criminal proceedings can start the reparations procedure. Also, we are now limited only by the determination of the perpetrator itself, but we cannot claim reparations from the state or from one of the entities. I am very limited in time here, and I do not have the time to give you all the examples, but here are at least some. I spoke to some of the victims, both those who had a positive outcome and those who did not. And I heard their opinions, and they think that this is yet another preventive measure, yet another conviction of the perpetrator, because the future generation who may find themselves again in an armed conflict get the message that whoever commits something like that will be held responsible and will have to pay up. We have seen that the climate is changed. It means that the judicial stakeholders now have a different attitude towards victims. Now we are witnessing a victim-centered approach. It also means that their satisfaction is much greater. They have all told us that they have sensed a great respect of the prosecutors and judges and other stakeholders towards their suffering. This means that we have managed to move them from the margins of the proceedings towards the center, because very often they would feel marginalized, and after the criminal proceedings everything would end up. Now they are in the center. Now they are being monitored and helped even post facto. Very often they would come to trial and they would see that the accused has lawyers, and these lawyers are paid from the state budget. They, however, do not have anything like that. Last year there was a new law adopted which now enables victims to hire lawyers at the expense of the state, at least in proceedings before the state court. I would also like to say one other thing. I think that we give greater satisfaction to the victims if we adopt this approach. If you just look at the recent decisions by the Constitutional Court, that those decisions do not involve any money, but they involve the principle of whether they are entitled to compensation or not. Sadly, they were negative decisions. So if we could have at least a decision on paper that if somebody was wronged, somebody should pay up for that, that would be different. One of the victims said, "This is very important for me, because now I can tell my child, whoever does something wrong will have to be held responsible and will have to pay up." Another important thing, when we look at those proceedings, we also elevate the level of protection of the victims to a higher level. When we attend these conferences, we talk a lot about victims, their rights, their compensation. However, victims know very well that when the lights in the conference hall are switched off, we have shocking decisions. For instance, when a victim engaged a lawyer before a lower court, they concluded that this somehow works against her. So, imagine when a victim is told, "Listen, don't write these things, don't hold us responsible, because our superiors then want to know us to write the same things, they want to consider us responsible. Why don't you just simply get a phone and call us and we can speak about it?" So, if I give you another example, the fact that a certain victim did not claim compensation was considered as the proof of the fact that her claim and her suffering was not serious. There are many institutions with an internal policy in place in which the right to compensation deserves a special attention. This is very commendable, of course. However, we have to raise this to the level of standard practice in all judicial institutions. It should not be up to individual prosecutors to decide whether they should approach these things in this way or not. We are very, very grateful to those who have changed their approach, but I cannot guarantee that all prosecutors will change their approach. That is why we need strategic documents. We need instructions within individual prosecutors' offices. We need clear definitions of all the obligations of all the stakeholders in the judicial process. We need yet another step in order to make all this meaningful. Prosecutors should also investigate the wealth or the lack thereof of the accused, so that once the criminal proceedings are terminated, we can go to the next step, and that is reparations. And now, one more thing that is not strictly limited to the judiciary, and that is the state should set up a fund which would pay out compensation in case that the perpetrator is unable to pay. Of course, we think that this fund should work for all victims of war crimes, and that brings us now to the original question. Do you think that victims of war crimes deserve reparations? It's very easy to achieve a general principled agreement. However, when we have to implement it, then we go into the issues of budgetary nature, of political nature, and we get lost. So I appeal on you that all of you, whatever function you have, prosecutors, judges, members of NGOs, I appeal on you to use whatever power you have and make that step so that the victims, or at least some of the victims, will get this additional satisfaction through the compensation that they have been waiting for far too long.
Thanks, Adriana. That was a very strong statement. A little bit of light that after so many years of no reparation at all, that there are now a few cases, that there is a witness-centered approach, and I know from my colleague prosecutors that they really want to put this in the center of their activity. But as you say, there is still a long way to go, and of course it is a scandal that victims are victimized again by having to go through all those proceedings, which very often are unsuccessful. And if they are successful and compensation is granted, well, in the majority of cases, they are still not receiving anything because the individual has not the means or doesn't want to pay because there are no proper financial investigations. So a responsible state should come in, compensate, and then turn himself against the perpetrator to recover the money spent. This should be the system, and the problem, I think, is that you don't have to convince anyone in this room. Those who need to be convinced are probably absent, like we are experiencing in many conferences of this nature. But I thank you very, very much, Adriana. We are more or less a little bit okay. We have 15, 20 minutes for questions. I have a few of them, but I think I will give priority to our, yes, okay, let's start with you.
Thank you. Thank you to all the presenters for their very helpful and informative presentations on this topic. I wanted to ask some questions about the issue of sexual violence against men. And especially since we have a lot of evidence of this happening, especially in the context of the Yugoslav conflict, yet we have very few cases that have actually resulted in convictions with regards to sexual violence against men, or at least that's been the criticism of the ICTY. So I was just wondering if you could speak a little bit to the issue of sexual violence against men. What has been the challenge, or why has it appeared so infrequently in the judges' judgments when it comes to the convictions of persons who've been prosecuted before the ICTY? And if you could just speak a little bit about what are some of the complexities that arise in that area. Thanks.
Let's take two questions. Who else wants to ask a question?
Microphone, please.
And please keep it short and ask questions. Thank you.
Dakle, ja sam Anđelko Kojesić, predsjednik
Anđelko Kojesić, representative of the Croatian Inmates Association of the Homeland War in Bosnia and Herzegovina. In order to contribute to this latest statement by Adriana, I wanted to tell you about something of the position of the courts in Bosnia and Herzegovina vis-à-vis those victims who seek reparations. The Supreme Court of the BiH in 2017, in September, stated that their decision is based on the Kakanj Basic Court, which was found to be without merit. Why was that? Because, and I quote, having in mind the fact that in the material period, during the wartime activities, the people concerned were inmates at the camp in the territory of Kaka municipality, and that during the proceedings they failed to prove that there was a valid judgment by the criminal court with regards to the accountability of the perpetrators for unlawful detention of the persons concerned as civilians. As such, claims for compensation for detention in Čatićevci, for the suffered moral damage and pain, and the deprivation of the right to freedom as well as inhumane treatment, and because of the suffering involved, it was manifested as the PTSD, interpreter's correction, and under the provision 436 of the Law on Obligations, we conclude that a statute of limitations is in place because both the subjective and objective limitation has expired to ask for compensation started as of the 23rd of December 1996, when the immediate threat of war was abolished. As a layperson, the way I understood this was that the courts believed the camp to be more of a dormitory, and that the women concerned more or less enjoyed spending their time there. That was my interpretation. Thank you very much.
Dobar dan i lijep pozdrav. Ja sam Jasmin
Mešković, president of the Inmates Association Bosnia and Herzegovina. I fully support this conference and its activity, as well as the ICTY efforts, but things are not as rosy as that. In our Inmates Association of Bosnia and Herzegovina, for the last 10 years, we have been trying to seek reparation for immaterial damage of the victims of torture. For the last decade, we have been undergoing the type of torture which was even worse than the one in the camp. The basis for our claim was because there was no law about the rights of the victims of torture in Bosnia and Herzegovina. In keeping with the decision of the Constitutional Court of BiH as far back as 1998, we find ourselves today in the situation where all those who had survived torture and the camps have to pay for court expenses, as well as the courts of the state-appointed attorney, averaging between 2,000 and 10,000 Bosnian marks per person. And that involves everyone who underwent torture and survived. When it comes to this part of criminal liability and the issue of reparations, I believe the best solution to be to undergo certain preparations, to put in place some kind of administrative reparation for all victims, irrespective of whether it involves sexual violence, detention, or other aspects of victimization. Together with the International Migration Organization and the ICTY, we made an assessment of the number of victims of torture in the former Yugoslavia, and you defined 3 principles. The best solution for all BiH victims would be to have those 3 reparation principles implemented across the board in BIH, irrespective of ethnic, gender, or any other affiliation. This was more of a statement than a question, though. So my question perhaps might be what the whole issue will, or how it will pan out, since we see very few positive developments. We have paid much more attention to the crimes and the perpetrators than we have to the victims. And now, in hindsight, we'd see this may have been a mistake, as our near future will probably prove. Thank you.
Thank you very much. And, you know, I really would hope that where we see that people can have difficulties agreeing who is a perpetrator and who not, I would really like to hope that everybody could at least agree who is a victim, and that victims' organizations at least could speak with one voice in that regard, because victims, as it was already said, independently from their own ethnicity and part of the country should have the same right in terms of compensation. I would say that, Michelle, you take the first question in relation to sexual violence against men, where I think we have a lot to say, and we have a chapter on it in the book. And then I would ask you to say something on reparations. Michelle.
Yeah, I'm happy to start with an answer on the issue of male sexual violence, and I suspect Kirsten may also have some comments on this because she's done some of the really groundbreaking early work on the issue of male sexual violence. I think we should hear from her as well. But yes, of course, I mean, part of what we were saying about the importance of recognising that sexual violence is a crime affecting both men and women has been an important lesson. We tend to have a very narrow focus on sexual violence and on gender. It seems to equate to crimes against women, and we know that's not true. So I think your point is very valid to raise here as part of this discussion. I do think, though, that we should be careful about assumptions we make about how these crimes are being dealt with at ICTY, because I think one of the often overlooked factors is that sexual violence against men has featured in our cases consistently and right from the very beginning. In fact, one of Kirsten's early analyses was about the surprising proportion of sexual violence cases that actually involve male victims early on at the ICTY versus what you might have expected based on reports of proportions of male and female victims. So, yeah, we should start with that. But still, I do agree that there are a lot of factors feeding into some of these perceptions. One of the issues we saw in our work was the fact that often sexual violence against men, of course, takes the form of sexual mutilation, often happening in detention settings. And often this was characterised not as sexual violence, but of course as torture. So the sexual component of it was masked, if you like, in the charging frameworks. We also had factual patterns which would amount to the crime of rape involving male victims, but you don't see it charged as rape in ICTY cases. So this is a comment we make in our book about, again, some of the stereotypes, the misconceptions, the assumptions around this, and the need to surface the sexual violence component of the harms against men, because although often it was prosecuted, it wasn't labelled that way. We also saw some interesting variances in the misconceptions around male and female victims, actually. So one of the things that we found difficult to overcome in our work was this idea that, especially when the victims were female and the nature of the sexual violence took the form of penetration, all of the honour and dignity stereotypes came out. So it was, well, that's terrible, but it's primarily a matter of honour. We weren't seeing it as a violent crime. And so therefore the seriousness that we attributed to it was minimised. With male victims involving patterns of sexual mutilation, we didn't really come across those same problems. It was really much more clearly understood, yeah, it's a violent crime and it's very serious and we should prosecute it. So there have been some differentials there as well.
Michelle, can you explain why? Why was it not charged as a sexual violence, charged as torture or some other kind of violence?
Yeah, I mean, of course we don't have a definitive answer, but we did probe this question a little bit in our study, and what we heard, because part of our methodology for the study was, of course, to interview a lot of past and present staff members in OTP who had worked on these cases. And often people would make comments around, well, it's precisely because of the stigma attached to sexual violence. So the investigators, the lawyers, and indeed the victims, the male victims, didn't want to be labelled as sexual violence victims because of the stigma. So I think that is a really important insight that we have to take on board for the future, because I suppose we were having some discussions yesterday, and I think the valid point was made by a colleague that you would have hoped that with the recognition that male and females can both be victims of sexual violence, that would help reduce the stigma. But instead what we saw is one category of victims, females, being labelled as sexual violence victims, and the other category tending not to be. So, but I will say, in the book launch that we'll have at lunchtime, we have a compilation of victim testimony, and we do indeed show that, yep, we had males speaking quite openly about their experience as sexual violence victims, and we had females as well. So I'll hand over to Kirsten.
I'll be brief because I keep assuming I can shout. Okay, I'll be brief. In terms of the question of underrepresentation, I just want to amplify what Michelle was saying, because what we see is, in fact, there is very significant testimony in ICTY cases, and indeed in BIH state court cases. So it is absolutely not the case that these are underrepresented prosecutions. So that's the first point. The second point is, this is a practical example of where we would want to talk about a gender analysis of conflict. The question is not how many women and how many men. The question is whether you are undertaking proportionate prosecutions of the patterns of criminality in the conflict. So it's not enough to ask in the abstract, what about male sexual victims? Although, of course, we might want to undertake representative or thematic prosecutions. That would be a different kind of discussion. However, I would argue instead, this is an example of what we would describe as a gender analysis of the conflict. Who was harmed, in what form, by whom, and how? And that's what we should be asking in terms of our body of prosecutions, and indeed our body of convictions, because that is the other issue, of course, rather than is it equal numbers of men and women, which of course is not meaningful in differently shaped conflicts that are differently shaped by gender.
Thank you very much. Diana, perhaps two words on compensation, reparation.
Evo, upravo iz ovih priloga koje smo čuli od predsjednika žrtava možete
Based on the statements of our Victims Association representatives, you can see the obstacles before the victims, especially after the Constitutional Court decision. There is this prevailing opinion that the decisions of the Constitutional Court may not be commented upon, but it is completely misunderstood, because it is one of the preconditions to develop positive jurisdiction. When you legally analyze the reasoning of the Constitutional Court, it makes no sense. It is brushstroke decision and does not meet the Charter of the Human Rights of the EU. The Supreme Court of the Montenegro and Bosnia-Herzegovina applied the law on obligation relations in the same way, which is part of the legal acquis, odnosno heritage of the SFRY. And Article 370 of the law on obligation relationships is the basis of their decision. As if you're a victim receiving that kind of explanation, you can just imagine the amount of frustration. Mr. Mešković, I believe at the beginning you said that things may not be as pictured here, and I believe we agree on that. I believe that sometimes the organization of Trial International, when trying to promote the new approach of reparations, is misunderstood oftentimes as the only correct way. That is why I try to say very plainly that we only represent one model of reparations. Another model would be the way you presented, which would be a collective administrative mechanism through which all victims across BIH would have equal access to reparations, and this can be achieved through a valid legal framework. However, when it comes to criminal proceedings, the issue on hand is different. I mentioned it already. Given the fact that we have victim representation, and when they have to testify in proceedings, which is difficult enough, we need to invest additional effort to make this effort strengthening for the victim, rather than something that will frustrate them additionally and making their rehabilitation process more difficult. In 2013, we followed a victim of sexual violence before an entity prosecution, and the person involved was well familiar with the criminal law. She was aware of her rights, and when she met the prosecutor and said that she wanted to raise a civil suit and reparations, he said, "Ma'am, you can only engage in that after we have done with this here." And then the victim is instructed to claim a civil suit, which never comes about. This all ultimately ends in the victim never fully facing the perpetrator, saying what she had to say. That is why we need to provide a plethora of means to the victims concerned to assure that they exercise their rights. For example, the case where the accused was pronounced indigent, the same issue arises as criminal proceedings, which is, can statute of limitations be applied in that case or not? All our previous legal attempts have failed. That is why we are trying to raise this project of strategic memorialization at the level of international organizations, where we will reconsider this general practice about statute of limitation. We have this practice under reconsideration as we speak. You know the Synergies and Bešić judgment against Croatia. A couple of months ago, we analyzed the judgment, and we created a parallel between the elements of that judgment and the situation in Bosnia and Herzegovina. We keep going back to that analysis. We keep going back to the courts, inviting them to interpret the provisions contained therein appropriately, so that no legal institution could require the victim to pay for certain expenses. For those who may not be familiar with the situation here, certain courts have indeed started implementing the judgment in question, refusing prosecutions requests for the victims to compensate part of the trial costs, which is certainly something that we need to promote further in the future.
I'm afraid we have to end it here. The conference starts again in 75 minutes with the next plenary. We have during this lunchtime 2 side events, so it's very busy agenda. So again, please a round of applause for our speakers. And you are welcome to the side events, also to get your copy of the book. And bon appétit, and see you later. Thank you.
Thank you very much. Please, we will serve lunch in the restaurant called Bosnia and Herzegovina. It is downstairs. You will see signs for it. And can we please be back here by 14:30? And of course, in between, we will have side events where you will also be able to have some sandwiches. So thank you very much. Till later.